my name is Jacques Bonvin. I'm a partner with NKF, Niedererkrath Frey, leading Swiss law firm based in Zurich and in Geneva. I'm myself in Geneva. I'm a corporate lawyer. I do mostly M&A, private equity, venture capital, with a strong focus on technology company. And in this context, I do advise regularly clients of all kinds on corporate law matters and corporate governance issues.
Thank you so much. So speaking about this corporate law, there are change now in the law, and we'd love to hear from you if this change are likely to make the requirements for the director a bit more stringent. What do you think?
I mean, generally speaking, the new corporate law does not really aim at strengthening the obligation put on board members. Some new provisions, however, require higher level of due diligence monitoring, and I'm sure we'll have the opportunity to expand a bit on that from the board, in particular regarding cash flow and capital coverage monitoring.
Okay, so by the way, speaking of this new law, do you think it will have more impact on a large corporation, SME, or startup, or is it the same for everyone?
I think all corporations are impacted at different levels. I mean, there are a few provisions in the new law that apply to listed entities only, such as the policy supporting gender representation at board level. But generally speaking, and I think that was true in the past as well, I mean, all corporations are subject to the same rules, except where certain thresholds apply, for instance, in terms of audit requirements and the like. But I think it's important for startups and SMEs to really understand that, they're subject to the same laws, and it's not that, large corporates are bound by all these rules, and then you have a different treatment for small companies, be they technology companies or family-owned businesses.
Yeah, thank you. Yeah, I think it is important that we remind that the law is the same for all sort of companies. So in few words, so what are these changes that everybody's talking about?
I think some of the change we hear a lot about are these questions about capital loss over indebtedness. That has always been a hot topic in terms of corporate law for SMEs and even more startups. And I think with the new law, the boards will need to act earlier in such situations. I mean, first, the board should closely monitor the financial situation of the company, again, be it a startup or SME. Then it should take measures as soon as possible to remedy any risk of capital loss or indebtedness. And the board liability in this regard is set at a fairly highest threshold, because there is a requirement now to put in place a number of monitoring instruments. And of course, I mean, using the accounts, the balance sheet, etc. But also be more careful with the budget and cockpit type financial indicators. So that's quite important. Plus, there are now certain restrictions where you have a company that has no auditors, that has opted out of audit. There is an obligation in certain situations to appoint auditors to review the accounts. Or there is also some restrictions on reducing the capital of a company if the company has opted out from limited audit.
Mm-hmm. Thank you for this highlight on the main change. So on another way, there is a question and something we heard about federal jurisprudence. About the fact that startup and SME have to be really paying attention to the fact that the re-election of the board has to be made within 6 months. Can you tell us what does it mean?
Yeah, I mean, first of all, again, it's a rule that applies to all companies, and the Swiss Supreme Court did not make any distinction between large or small companies. And I think that there's always been this rule in the law that says that you have to approve the financial statement within 6 months of the end of the financial year, and at this annual general meeting. At the same time, you have to re-elect board members. this rule was always considered as a rule with no sanction, but now the Swiss Supreme Court says it's important to abide by these rules, and in certain situations, you may have an issue with the validity of decision taken by board members who have not been properly re-elected. And this is valid for most companies because most companies have a system where board members are re-elected on an annual basis. Of course, it's different if you have a company that elects, board members for say 3 years, and then the re-election happens only every 3 years. Then you don't have this issue of re-election. You still have the question of holding the annual general meeting, and you still have the question of making sure that you approve the financial statement within 6 months of the year end. But it's a bit different than for the board members. So I think, all in all, or in short, companies should always, try to get their annual general meeting within 6 months from the end of the financial year, and not forget at this occasion to re-elect board members.